So, guys, first of all, thank you for coming. I'm Jeffrey West, president and founder of Freedom Financial Wealth Management, and welcome to what's become our ongoing Wednesday workshop, as known as Wednesdays of the West. Tonight, I'm actually honored and privileged that we're going to have a special guest by the name of Jeffrey Bellomo, Esquire. He has been rated the top estate planning attorney, I believe, for the last 4 years in York County. I've known Jeff for a number of years now, and I know I'm maybe partial to the name Jeff, I don't know, but I was instantly blown away with his knowledge and his approach and his personality and the way he really connects with his clients. So he's decided to give us some time tonight. So thank you for taking away from your personal and family time, Jeff. It really means a lot.
Absolutely.
Discussing is what is called What If I Get Sick? And the basic concept here is, guys, COVID's out there. It's scary. You turn on the news. It's down in your face. We recently actually had a client who cut her hand open on a glass that broke in her kitchen, and she was too afraid to go get stitches because she didn't want to go to a medical institute where she might contract COVID. The fear of getting sick is bad, and the fear is about staying healthy and living and that end of it. But there's a whole other fear that we as a financial firm feel you're missing, and we want to talk about that tonight. And the best way to deal with fear is have a plan. And Jeff has joined us tonight to talk about what if I get sick and what you actually need to have in place from a legal point of view so your financial and personal matters can continue to be managed by somebody who's not sick. So without further ado, let's bring up Jeffrey Bellomo. And let's do that. There we go. Hi, Jeff. Good evening.
Hey, good evening, Jeff. How you doing?
I'm unbelievable.
All right. Nice.
So Jeff, you want to take a minute, introduce yourself, talk a little bit about your firm, bloviate a little?
Yeah, sure. So we're Bellomo & Associates. We're a York kind of based law firm, although we do have an office in Lancaster, and we do also go up to Harrisburg and Dauphin County quite a bit. We specialize and focus in nothing but estate planning and elder law. I'm a certified elder law attorney. I have a master's in tax and estate planning, and I'm kind of boring. All I do is this area of the law. I don't handle anything else. We as a firm do just these areas, so we certainly enjoy what we do. But yeah, that's a little bit about our firm, and I'm loving working from home at the moment. Actually, I'm kind of enjoying it. So,
looks like you have a beautiful family on the wall behind you, and now you obviously are blessed to be able to do that.
Yeah, amen.
That's great. So let's start off with the simplest of all questions. How do you even know if you need documents? I mean, why would I even know if I need to do anything?
You know, I've said this for years, so this is not something that has changed because of COVID, but everybody over the age of 18, I believe, needs to have, at a minimum, a financial power of attorney. And many people have heard me, speak and seen recordings of me where I've actually gone out on a limb and said that I believe the most important document that every single person should have is a financial power of attorney. I'll spare you the dissertation as to all the reasons why, but what we find, like this time of year, is we end up doing more financial and medical powers of attorney than we do. We end up doing more financial and medical powers for 18-year-olds right now going off to college than we do any age group, because people realize that once they are 18 and they go off to college, mom and dad cannot make financial decisions anymore. Mom and dad can't call the college and find out what's going on and get information about their grades without a power of attorney. So it kind of, for me, hits home as to some of the reasons why everybody needs it. At a minimum, a financial power. There is a healthcare statute that provides that the next of kin can make healthcare decisions, but I hate to rely on any sort of statute, but that's why I'm saying that financial powers are probably the most important document, that if you became sick or unable to make your own decisions, to have someone else do it for you.
Yeah, I know as best practices at our firm, every client, we require them to have one to even do business with us on the front side. But that's not an industry standard, that's our firm standard. I can't tell you how many times husband's gotten sick in the nursing home or so forth. Wife needs to draw money from his retirement account and without the financial power of attorney. It's that simple. Yes.
Yep, it is. Absolutely.
Okay.
And I think what happens, Jeff, and you already alluded to it, but I think what happens is people assume that because they're married, their spouse can do whatever they need to do on their behalf. But what people seem to forget is, a lot of us do have assets in our names alone. A lot of us do own a retirement account, and retirement accounts are owned by a single individual. So if you lose capacity or the ability to make a decision, your spouse can't do it simply because they're a spouse. There has to be a power of attorney. So I agree 100%.
All right. So is there a bullet point list or a quick rundown of the basic documents that you decide that everybody should have?
Yeah, I mean, we tend to just say, everybody should have a financial power of attorney, a medical power of attorney, and a living will kind of attached to the medical power of attorney. And when you combine those documents, a medical POA and a living will, they also call it an advanced healthcare directive, and then a last will and testament. I would say that if you were kind of saying to me, bare minimum that everybody should have just to make sure that their bases are covered, those three documents would provide not only if you became incapacitated, but also then if you died with assets in your name alone. So I would say those are the three basic.
So I've heard a lot of times that if I give somebody my power of attorney, now they can just run around and steal my money or take off with it, or, I can't stop them. Is there a way to revoke power of attorney or make sure they're not using it improperly?
Yeah, so you actually said a lot right there. You asked a lot of questions. So I think maybe the best to kind of address it is start from the basics, which is in the old days, people would make financial powers of attorney what we would call springing. So an action had to occur for them to spring into power. And what that was typically was if five physicians put in writing that this person is incapacitated, the power of attorney becomes in effect. Well, come on, we all know what it's like to get two doctors to do anything in writing, certainly in a hurry, right? So that kind of went by the wayside. And then we went to making powers of attorney durable immediately, which means they're effective immediately and they last through incapacity. But what was happening then was what you just said, which was people were running around, taking advantage of mom or dad when they were down in South Carolina. So what we did internally, and a lot of attorneys across the country do this, is we have the POA say that it's effective immediately. But then we have the client sign a document with our law firm that says, hey, and Bellomo and Associates, you keep the original of my power of attorney. And don't you give it out until I tell you to give it out or I'm incapacitated. And in order to make the determination of capacity, you can meet with me in person or speak to my doctors. And here's the HIPAA language to do that. That pretty much puts the burden on our law firm that the financial POA is in effect, but it's in our safe in the basement. And I can only give it if you tell me to give it or if you're incapacitated. So that has been the happy medium, which is I consider it still a springing POA that's taking you either to tell me to give it away or you're incapacitated, but it doesn't take two doctors to put it in writing. I can make that determination myself.
Wonderful. Well, that puts a lot of liability back on you and your firm. And you're comfortable with taking that?
Every year, my malpractice carrier asks me to reevaluate my position. But you know what? What I said to them is the only liability that I'm taking is that if I give it out before they tell me to do so. Because if I meet with the person and they lack capacity or the doctors tell me, I'm protected because it is my determination. Jeff, the one time I actually had a client meeting, I could hear the front door slam. I heard a son ranting and raving about his mom being in a car accident. And in those moments, your blood starts to run, you get anxious, you get excited. The client that I was with said, Jeff, you need to go take care of that. Take your time. I'm in no hurry. Take your time. So I went running out to the lobby and he was like, my mom was in a car accident. She's at the hospital. I need the power of attorney immediately. So I go running back to the safe. I get the document. And as I'm walking up the steps, I look down and I saw it say, only give this document out if I instruct you to do so or I'm incapacitated. And somewhere in that moment, I went, huh. So when I got out to the lobby, he reached for the document. I withheld it and said, well, now, wait a minute. Your mom did not tell me to give it to you yet, and I don't know if she's incapacitated. I just told her she was incapacitated. I said, yeah, I know, but I need to verify that. So if you're familiar with York, I was coming down South George Street, and instead of, like, I was going to the hospital, and instead of making that left-hand turn around on South George, he went up Tyler Run Road and left. I looked in my rearview mirror, and I'm like, what the heck? So I get to the hospital. I was not in the hospital. His mother was not there. She never had an accident. The next day, I was calling the mom at noon when I had an opening. She called at 10:30 to tell my law firm that she can't find her son and he disappeared. He was going through a divorce, and he was really disappeared out of the country, waiting to wipe his mother out before he left. And I would have been personally liable had I given him that document.
Good insight on your part.
Yeah, that serves as a reminder to me. Every time somebody asks for the document now, I don't go get the document until I talk to mom.
All right, so now I have a POA in place. Everything's good. Lord forbid, I mean, I'm sick. My financial matters are being taken care of by somebody I trust.
Okay.
And then my power of attorney, just if I do happen to pass away, Lord forbid, he can just do that too, right? That's what POA does, or am I wrong?
No, so the POA actually will die with you. So the power of attorney ceases at the moment of death, and the last will and testament will then kick in, and then the executor that is named in your last will and testament will be the person that will, after they fill out the probate petition, they take an oath in the courthouse, they're given letters testamentary or short certificates. Once they have those short certificates, the executor steps in your shoes and they are you, and now they can transact business on your behalf. But from the moment of death until the executor takes the oath, there's actually nobody who's in charge during that, maybe 2-week period. But that's okay. I mean, creditors understand that they're not going to get paid right away. Know that they will as soon as the estate is open. People panic about that, but they really shouldn't.
I recently had a client who had her name on her husband, or had a power of attorney on her parents' account or mom's account, and mom passed away, and she got into a fight with the bank because she was POA and should have access to the account to pay mom's bills, but mom was passed away, and therefore the POA didn't matter anymore. And the bank assured her she could, and then that happened, and she couldn't. I think there's a lot of confusion around those points out there, and I just heard that story 6 months ago, and I couldn't help but make sure you clarified that.
And to be honest, Jeff, I think there's, I've had conversations with bank tellers and bank officers who also didn't know. So I think it's definitely something that is not probably as well known as it should be. So yeah, I definitely agree.
We have a general practice. Yes, Kevin.
The way I got around, I was a power of attorney for my mom, but so I didn't have to deal with that. We put my name as a signatory in her account at the bank.
I'm glad you brought that up. That's something we actually recommend against.
Well, when she passed away, I had to settle her estate with the state of Pennsylvania, and the only way I could do that was have access to those funds.
I hear what you're saying. So
I did not go to the courthouse and take an oath to execute a will.
Let me make sure. I'm glad you brought that up, Kevin, because I think that's something we should talk about. We as a firm generally do not recommend that as a practice for clients setting up our accounts. And Jeff, please correct me if I'm wrong, because once you're a joint signature on an account with mom, that money becomes your money. And if you get sued for some reason, Lord forbid, mom's is now on the table for lawsuit.
That's a good point.
And then you could end up, by no fault of your own, just a bad car wreck that you made a mistake on, wiping out mom's entire account. Is that correct, Jeff?
Yes.
Well, I didn't realize that because I paid her bills out of that account, never thought about it.
All you need to do, that's what the power of attorney prevents. It gives you that access without taking the liability of the money on top. On top of that, Jeff, I believe there's some stuff around estates and around nursing homes that makes it a lot more confusing as well. Is that correct?
Yeah. So, what, Kevin, that's an interesting point. Smiling as you were saying it, and I was just about to jump in, and Jeff beat me to the punch. when I do workshops, I actually teach in 3 different lands across the room where I say, okay, I'm in tax land. Now I'm in long-term care land. Now I'm in estate planning land. And I literally run from each corner of the room back and forth. And that's one of the examples that I give is, okay, let's address adding a joint owner on an account from a tax perspective. So if mom dies first, Kevin now only has to pay 4.5% tax in Pennsylvania for inheritance tax purposes only on half of the account. Okay. Now, if Kevin dies first, mom has to pay 4.5% tax on half of the account. And I can tell you that I've been the attorney who had to make the phone call to mom to send her condolences of the loss of her son, Kevin. But, oh, please don't forget that you owe 4.5% tax. That conversation never goes well.
No, I guess not.
No, never good. And then the other thing that people don't realize is that I had this case as well. Mom transferred the assets as a joint owner to the daughter. The daughter had a stroke. Daughter's family hires me to fill out a Medicaid application to try to preserve assets for her minor children. I fill out the app. I argued that only half of those assets were available, right, for the daughter. And the caseworker said, well, Jeff, the day before the stroke, how much could the daughter have pulled out of all those accounts? And I said, well, 100%, right? I mean, if you walked into the bank, you could pull out 100% of the money. So they said, okay, well, 100% counts. Then the mom gets sick, which is what we were afraid of originally. Mom ends up in the nursing home. Family hires me to do an application for her to try to get money protected for the grandkids now, right, for the daughter's kids. And the caseworker says to me, well, I noticed that you omitted those assets. And I said, I didn't omit them. It was intentional. It wasn't accidental. I did it intentionally. When I go to Marcello's and I get a pizza and I eat the whole pizza, there's nothing left. And you, on that first application of the daughter, ate the entire pizza. So there's no pizza left now. And the caseworker laughed and she said, oh, no, Jeff. And I said, oh, come on, spare me. Save the argument about the day before the stroke. What could mom have taken out of the account? And she said, oh, I would never use the same argument twice. Who contributed the money to the account? Mom. So what did? She counted 100% against mom. So one of the soapboxes that I get on is all the reasons why, and the reason people do it is they call it convenient, right? It was very convenient for you because it worked. But one of the presentations that I give in the community is why that's the most inconvenient thing you could ever do. And I for an hour. So I think it worked out for you. So, hey, you know what? It worked. Life is good. But I'm with Jeff. I'm a little hesitant to do that in a normal case.
So,
Well, I've taken notes, so that's very interesting. Didn't even consider that.
So Jeff, if I want to be able to get a hold of mom's assets after passing quickly without getting the law involved or too crazy, is there a document that can speed up that process?
I mean, a couple of thoughts. You know, you could avoid probate by either a beneficiary designation on the accounts. You could do a living trust to avoid probate. But to be completely honest with you, I mean, by the time the funeral happens, most people typically have a death certificate at the funeral, or at least, you know, pretty close in time to the funeral. Once you get the death certificate, you're down in the courthouse taking an oath for 10 minutes. And once you take the oath for 10 minutes, you have the short certificate to be able to close the accounts and put everything in a state account. So, you know, we're only talking maybe an extra day or two. So to me, there are reasons to do trusts. There are reasons to use, you know, beneficiary designations. But I always say, don't do it solely for the purpose of convenience. There has to be another reason, which I'm sure we'll talk about later.
So what for the benefit of the audience, I think the word probate gets used a lot by you and I, but they don't necessarily understand what that means. What is probate?
Yeah, the way I explain it is probate is the state's rule book. So if you own an asset in your name alone with no benefit designation on it, it's not in a trust, it's not jointly owned, it's just a single account with no beneficiary, that must go through your will. Your will must go through probate. And probate is really the state's rules as far as the executor goes down to the courthouse, the executor raises his or her right hand, takes an oath that they will duly administer the estate and abide by provisions of law related to inheritance tax. They fill out a form, they get the short certificates, they have to have the inheritance tax return filed within 9 months of the date of death. And there's some basic rules that are set forth. But the thing that people, I think, often forget, and I think the thing that people often miss, is that if I do a living trust, for example, or I do a beneficiary designated account, they're still taxable. Pennsylvania still requires the tax to be paid and still requires the inheritance tax. So the one thing I always explain is there's really only one asset that Pennsylvania is not going to want their money: life insurance. Life insurance is the only asset that's exempt from inheritance tax. But outside of that, every other asset requires inheritance tax to be paid, requires an inheritance tax return. Now, there's a good chance, and I'm not asking Kevin to answer this. This is being recorded. So, Kevin, I don't even want you to acknowledge this. But I'm going to go on a limb and say that you probably never paid inheritance tax on the joint account because there were no other assets in mom's name alone. The bank probably didn't trigger it with the Department of Revenue, and you probably never received the letter that said, why didn't you pay your inheritance tax? But I will say that is by far the exception to the rule. And it almost always gets picked up on. The banks almost always report it because they have to. And so it really doesn't save much. You're not saving inheritance tax. Like I said, you're only saving a day. So there are other reasons to do revocable and irrevocable trust for asset protection purposes, avoidance. If you own property in 3 or 4 or 5 different states across the country, you don't want to have to open an estate in 3 or 4 different states or 4 or 5 different states. But if you don't have property in different states and you're not interested in asset protection, Pennsylvania is actually probably the easiest state as it relates to probate. It's very simple. We don't have to go into court to get an approval. You can close the estate by a family agreement. So for the most part, probate isn't really a bad thing in Pennsylvania like it is in some other states.
So you keep using the word trust, and I remember when I became an advisor 20 years ago, the education I had to go through to understand trust, and I feel like there's a huge difference in lack of understanding. So when I say living trust or revocable trust versus an irrevocable trust, could you explain the difference there?
Yeah. So, well, let's start with the first comment, which is a living trust basically applies to all trusts that are created while you're living, whether revocable, whether irrevocable. So a living trust is a trust created while you're living. A testamentary trust is a trust that's created in a will, and the will, of course, does not take effect until you die. So living trust created while you're alive, testamentary trust created in a will. Now, if you have a living trust, we know it's a trust that's created while you're alive. There are 2 main types, revocable and irrevocable. And I apologize, you have to bear with me for 1 second.
You're getting the wagon. He's getting the wagon.
I was not prepared or thinking that I was going to bring the wagon out tonight, but you know what?
I feel like you steered the conversation to the wagon.
So, the way that I teach trust are through the use of the wagon. And the reason I use that is because most of us can relate to a Radio Flyer red wagon from when we were kids and we were pulling along the wagon with our stuff in it, right? So I think a trust is a lot like your wagon as a kid. Your most important stuff is close to you. You're the person who is kind of carrying the handle of the wagon and pulling the wagon along in life, right? So a trust is a contract between 3 people. The grantor, the person who creates it, the trustee, the person who controls it, the beneficiary, the person who receives it, right? So That's all a trust is. It's a contract between those three people, those three parties, and what's going to happen. So I'm the grantor of the trust. I create it. I'm the one who's deciding what this wagon looks like. I want to be the trustee of the trust because I want to control it. And I'd like to be a beneficiary because I'd like to enjoy or use the assets that are in the wagon. So if this asset is my house and it's titled Jeffrey and Whitney Belomo, who can live in it? Jeff and Whitney.
You deem fit.
Who can sell it?
You.
Who can buy another one?
You.
If I take the house, Jeffrey and Whitney Belomo, and we put it into the wagon, now it's titled Jeffrey and Whitney Belomo, trustees of the Belomo Trust. Now we know about this property is that it's owned by the trust, but who's in control?
You.
Jeff and Whitney. The trust document's going to tell me that Jeff and Whitney can live in it. Jeff and Whitney can sell it. Jeff and Whitney can buy another one. Gee, Jeff, when it was out here, we could live in it, we could sell it, we could buy another one. When it's in the wagon, we can live in it, we can sell it, we can buy another one. What the heck's the difference? Well, it depends if it's revocable or irrevocable. If this trust is revocable, I can reach in tomorrow, take the property by myself and put it back in my name. Essentially, I'm taking all of the stuff in the wagon and I'm walking away with it. I'm taking my toys and I'm playing in another sandbox. Well, if I can revoke the trust, that's revocable. That means that I get no asset protection because debtor-creditor law says whatever I have direct access to, whatever I could just reach in by myself, so too does my creditor. So the reason that we use revocable trust primarily are for people who own assets or property in 4 or 5 different states across the country. They don't want to have to do a probate in Pennsylvania, Maryland, Florida, Connecticut. They want to avoid the probate process in 4 or 5 different states. But if it's revocable, there's no asset protection. Now, an irrevocable asset protection trust would allow me to get asset protection for the assets in the wagon. And because most of I don't have any clients that have more than 23 million. So currently, the federal estate tax limit says that husband can transfer 11.58 million during his or her lifetime. Wife can transfer 11.58 million during his or her lifetime. That's over 23 million. I don't deal with clients typically that have more than 23 million. If you know any, let me know. Happy to help them. So most of my clients don't have a federal estate tax problem. So when I talk about an asset protection trust, I'm not talking about a trust for tax purposes. I want it to be included in my estate. I want my kids to pay 4.5% inheritance tax because I want to step up in basis. I want my kids to get the basis that I had at the date of my death, not at the date that I purchased the asset or the day that I purchased the item. So these asset protection trusts, the only thing I'm giving up is I agree that I'm not going to reach in by myself and put that property directly back in my name. But if you're listening, you'd say to me, well, gee, Jeff, if you can live in the house and nobody can kick you out, if you can sell the property because you and your wife are the trustees, and if you could buy another, why the heck would you ever need to put it directly back in your name? And the answer is you wouldn't. In 20 years, I've never needed to do that. So that gives me asset protection. It allows me to have the step up in basis at my death.
So what are we protecting these assets from, Jeff?
Creditors, you know, people will say to me, yeah, but you have auto insurance. You know, I agree. You know, I have 300, 500 on my auto, and I'm confident that if I don't kill 3 or 4 people or more, I'm okay. But you know, that's tough to say. I do have an umbrella policy that I purchased just because I'm afraid. I'm a lawyer, so I loaded up on some umbrella and I loaded up on my auto insurance. But you know, my thing is if I'm in an accident, I can't say I want to hit that car that has one person in it. I'm going to swerve and hit the van that's college students who are all going to medical school and they're on their way to an event and there's 12 of them in the van. That's my luck. So one of them is creditors. The other one is long-term care costs. So in our area right now for long-term care, we're looking at about 12 grand a month. So one of the things that we're trying to protect from is having everything that we work for our whole lives to get lost to a long-term care cost, and these trusts will do that.
Okay. So I guess that really leads down to, is there some, I lost my thought process. I apologize. Oh, I know what it was. So is there any advice as far as choosing the person that you're willing to put as the power of attorney or the executive? Is it a person? Is it people? Is it an or? Is it an and? And if you change that, what about somebody's feelings getting hurt? Is there any advice you have there?
Yeah, I mean that's a great question, and there's no perfect answer. The financial power of attorney right now in the state of Pennsylvania, banks are not allowing us to say and. So I have a sister whose name is Dina. My father wants Jeff and Dina to make financial decisions for him. A lot of banks are not accepting and because they can't guarantee that both Jeff and Dina are going to sign the back of the check because everything's processed electronically now. And so the banks don't want the liability if only one person signed on it. So they're making us say or Jeff or Dina. Well, that's a big difference, right? Because if Jeff shows up at the bank at 9 o'clock and takes out 20 grand and doesn't tell Dina, and Dina shows up at 1 not telling Jeff, we're going to bounce a check, and we didn't know, but we didn't have to tell each other. So I don't love that. I have a big problem with it. I think you're going to see that there's going to be a suit sometime in the future against the banking industry. But for right now, the only option they're giving is if your document says and, we'll only accept it if Jeff and Dina will sign an indemnification agreement that says that if Jeff or Dina takes money out of the account, that the other one, Jeff or Dina, will put the money back personally to the bank. Bull crap. I'm not signing that. There's no friggin' way I'm signing that. So essentially, we're forced right now to say or right now, or to pick one. On the medical side, you can absolutely say and. I find that a lot of parents like to say and because they want the kids to have to agree. So, if we're dealing with mom and dad in the hospital, they want the kids to have to agree. And for the most part, that works. But you and I both know that not all kids are going to agree on whether mom should have surgery or not have surgery. So I've had to break up a few fights in the hospitals, literally fist fighting brothers. I think what I always tell people is, your family better than anybody. You don't owe anybody anything. And as much as you don't want to ruffle feathers, you're going to no matter what decision you make. So you might as well make the right decision for you.
So what about people changing these things and concerned about mental capacity of the individual making the change? So I'm 72, 73 years old. When I was 40, I picked my son or my daughter. But, over the years, they become less reliable, and my other child became a lot more reliable, a lot closer. I want to make that change. Is there a way to check their mental capacity?
The only person who really can do that is the lawyer who is determining capacity at the time that they're signing the document. So that's another question that comes up a lot is who actually determines mental capacity? And my answer always is, for what purpose? Well, what do you mean? Well, if you're in a hospital and we're determining if the person has capacity to make a healthcare decision, it's the doctor. If you're in the lawyer's office and you're signing a power of attorney, it's the lawyer. If you're in a courtroom because somebody filed a guardianship hearing to have a guardian appointed to take away your rights to make your decisions for yourself, it's a judge. So it depends on what the context is. who's going to make that determination? And you and I were talking earlier about the financial professional boot camp that I have coming up on Friday. But the one boot camp that I really love is the healthcare boot camp that we offer. And we just had one a few weeks ago. And we've got we had like 50 some healthcare professionals coming to it. But the main topic in that boot camp is always, Jeff, why is it that when, Kevin has a marking in his medical chart that says that the doctor doesn't believe that Kevin can make medical decisions for himself, why is it that that idiot lawyer allowed Kevin 2 weeks later to sign a power of attorney? How did that happen? And then I have to explain that depending on who's making the determination, that's who makes the decision. And the decision is made in that moment. So legal capacity requires that you are lucid in the moment. So if I meet with a client at 9:30 and he answers the questions, he knows who he is, he understands who his family is, that's capacity. If 2 hours later he thinks he's George Washington and he tries to jump off a building because he thinks he can fly, he still has capacity at 9:30.
So George Washington could fly. Okay.
You didn't know that?
Jeff,
So I think go ahead, Lisa. I was going to open up to questions now. Is there something you'd like to ask?
yeah, I'd like to ask a question about that. If the person who's signing is in the attorney's office, but has an actual diagnosis and is in a facility for dementia, you're saying that attorney can decide?
Absolutely. Dementia by itself does not preclude legal capacity. Legal capacity is determined by, in that moment, does the person know who they are? Do they understand who their family is, what powers that they're giving away? I'm absolutely saying that. That is 100% what I'm saying.
But what if they don't ask that?
I'm sorry, Elise?
What if they don't ask those questions? They
Well,
just
then
sign this.
then the lawyer is sticking his or her neck out on the line, and they're being silly and they're being stupid. Because you do need to be able to defend it. I mean, I can tell you in any case that we get involved in where there's even a remote possibility, if there's any markings in a chart, if anybody has referenced the fact that they seem confused, we document the heck out of the file as to what questions I asked, what were the responses. I make note of their eye contact. I make note of their inflection. I make note of everything because I want to make sure that I document the file. And I'll make sure that I've got the two witnesses standing right next to me. I mean, if there's a question of capacity, we make sure we document the crap out of it. If your example is, well, they didn't ask any of those questions, they just had them sign, that's not a good idea. That's not good business.
Who are the witnesses? Can they be the person's daughter who's going to be the inheriting?
It has to be an uninterested party.
Okay.
So if Jeff is named in the document, Jeff cannot be a witness.
Okay. Thank you.
You're welcome. It sounds to me like you have a specific sort of fact pattern or case that you're kind of curious about. So
No, I'm not. It doesn't really matter to me, but my friend's daughter changed his will that he did when he was alive and oriented, took him to an attorney who changed his will when he was already committed to a nursing home for dementia. Now, I don't care. I'm not a recipient.
yeah. Well, here's what I will say about that. I mean, obviously, as long as it's not me, no, I'm joking. I don't know. I mean, I think that on one hand, you have to give the attorney the benefit of the doubt because he's licensed, he's an attorney, he has held to a certain standard, he or she. But on the other hand, if a person went into a facility knowing there's a dementia diagnosis and didn't ask any questions and didn't have two witnesses with them and had them sign, that's reckless. I mean, that's not smart.
I've actually had other clients whose attorneys who were getting things changed actually send the person out for a capacity hearing from a medical professional before allowing them to change documents. I've seen that practice as well. So
Yeah.
lots of ways to go about it.
Yeah, I think it all comes down to the comfort level of the attorney. I mean, I was called to the stand one time by somebody who was basically arguing what Elise was saying in that case. And I got up on the stand and I was able to show, Your Honor, here's a video of me walking into the nursing home. I had 2 witnesses with me. The room, I asked these following questions based upon my notes. Here was the response. Here was the way he responded. I had all those notes about what occurred. And the judge literally looked at the other attorney and said, look, you're asking me to determine that an attorney who has 20 years experience, who's a certified elder law attorney, who specializes in this area, who has notes from that day of the questions that he asked and that he was comfortable with the person answered them, you basically are asking me to call him a liar. Is that what you are saying? And no, I respect Jeff tremendously. He's the best in the business. And the judge said, well, what do you want me to do? He's testifying that this is what occurred that day. I believe him. I absolutely believe him. So it almost sounds like in the case that she's talking about, maybe that didn't occur. Maybe the attorney didn't ask those questions, but maybe he or she did. Obviously we don't know the whole story. We don't know exactly what happened, but I always tell people if the family's not sure, it never hurts to push back a little and just ask some questions.
This person was sure they didn't ask questions. I was in the room.
Oh, you were in the room?
Yeah.
Oh, wow.
Yeah. So you're a disinterested third party, at least, is the answer there. So you're a really good witness for the person that feels slighted.
Oof, yeah, big time, at least.
Yeah.
Yeah, you're carrying some weight on your shoulders there. All right, so I think we started out this event with talking about making sure we had our proper documents in place for if you get sick. So your personal financial matters can continue on while you're recovering. The country is starting to recover now. The markets have done great for the last couple of days. We're very pleased as a firm. We're very happy as where things are headed. The original diagnosis of complete economic disaster does not appear to be the result. We're happy as a firm. We are here for you. Jeff, I know you and your firm are here for your clients, and if anybody wants a referral down to Jeff, I'd be glad to make it at any time. We do a lot of joint work together. Kevin, do you have another question? You're on mute, buddy. Still mute. Let me unmute you. I can't unmute you, Kevin.
I'm always on mute when I'm on a Zoom meeting. Yes, I do need to probably talk to you.
Okay. I will personally get you his information, Jeff. I have it on, and I'll text it to you when we hang out. Get it over to you. That's great. Okay, at least great. And I tell you might already have his information. Jeff, again, for your time this evening. If there's any other questions from the people on the call, no? Great. I really appreciate your time. I feel like we got a much better handle. I want to say, make sure you join us next week. We're going to have another one of these. It's actually a weekly webinar series for now until whenever. We're calling it Wednesdays with West. So, that's kind of cool to remember. Our special guest next week will actually be Kevin Fitzpatrick, professional headhunter and recruiter. He will be helping people who just lost their job know how to stand down in a crowd of a lot of other applicants so they maybe get hired quicker. Pretty smart in that area, a lot smarter than me. He doesn't have COVID cut problems. He can take care of that a lot easier. I hope to have had a haircut by next Wednesday. I hope you've had a haircut by next Wednesday.
I don't have a problem.
Yeah, keep shaving. I hope you and your families are safe and secure. If anybody needs anything from our firm, please do not hesitate to pick up the phone and call. We did get the honor of reopening Tuesday morning. We have sanitation crews in daily. We have sanitizer. We have thermos checks. We have masks. We have whatever you need to feel comfortable. But if you're still in a position where you're not comfortable, we can do video calls like this from your office, or telephone calls like the old days. We can't do smoke signals. Those don't work so well, but we do have lots of other forms of communication. We thank you for taking your time this evening, and we look forward to seeing you all again next week. Have a good night, everybody.
Thank you.
Thanks, everybody.
Thank you.